Good morning, Your Honor. My name is Buckner.
Your Honor, as to the PCC itself, we would be requesting an adjournment for further negotiations. Then I would also like to address bond appropriate.
May.
Thank you, Your Honor. So Mr. Buckner has been in custody from July 6th, so he's been in for 10 days now. I believe that
is that the result of his bond violation?
Yes, Your Honor. I believe the allegation for the bond violation was a retail fraud. My understanding is that the people have not authorized anything as of yet. So as of right now, there's nothing to admit to. So I guess we would be requesting an adjournment of the violation itself, given that there is no charge as of yet. And then I would ask to address bond when appropriate.
Go ahead. Anything?
Well, let's address on first.
All right. Well, what I will do is I will probable cause conference. I'll adjourn to. I can go the 28th or the 6th.
The 28th would be fine with us, Your Honor.
I'll adjourn this to July 28th, 2026, 9 a.m. That's a Tuesday, by the way. All right, as to bond.
Thank you, Your Honor. So as I stated, Mr. Buckner has been in custody for 10 days now. His fiancee, Heather, is in the courtroom today. She's in the front row in the wheelchair. Mr. Buckner supports Heather and is an important part of her life in helping her get to doctor's appointments and making sure that she's able to get around. She has been in a wheelchair since, was it February? So yeah, since February, Your Honor. Additionally, Your Honor, Mr. Buckner stated to me that he does have a job offer at Potbelly and that he is accepted. He stated he has until July 21st to let them know, and that if so, he can get out and he can set up an orientation. And then additionally, Your Honor, he stated that he is looking to start school again. He's going to start back up working on taking online courses at Colorado Tech. At Colorado Tech, Your Honor, his long-term goal is to become a counselor for at-risk youth. And then lastly, Your
Why
Honor,
wasn't he here on June 25th?
Yes, Your Honor. So on June 25th, so he logged in on June 24th accidentally. And then on June 25th, his phone died. He had to go to the First Baptist Church in order to get a charger. He then called in, but it was too late. So he did then call our office and got the bench warrant recalled on June 29th, I believe. And then it was rescheduled for a PCC on this date. So he had no intentions of missing court that day. It was just that his phone died.
Why is he in custody?
He was in custody on the alleged bond violation, Your Honor. And then
retail fraud.
The alleged retail fraud, yes.
So just so that I have this all clear, he's on bench warrant status at some point, recalls the bench warrant, then picks up another potential offense.
Yes, Your Honor.
Any response from the people?
This is the first point where the hearing shifts from mitigation to judicial risk assessment. Up until now, the defense has emphasized Mr. Buckner's family responsibilities, a job opportunity, educational plans, and an explanation for missing his earlier court appearance. Those are all common mitigation factors, but none of them automatically outweigh the court's primary concern, whether the defendant will comply with future court orders and avoid new criminal conduct while released. Notice how Judge Simpson carefully reconstructs the timeline before making any decision. He isn't simply asking questions for clarification. He's testing the reliability of the defense's narrative. The sequence involving the missed appearance, the recalled bench warrant, and the alleged new offense becomes legally significant because judges frequently evaluate patterns of behavior rather than isolated explanations when deciding bond. There's another important detail viewers may overlook. The alleged retail fraud has not yet been formally authorized, but the court is still permitted to consider the circumstances surrounding the alleged bond violation when evaluating release conditions. Do you think the personal hardships presented by the defense are enough to overcome concerns about repeated compliance with court orders? That balance is exactly what the judge is weighing before ruling.
Your Honor, you have asked all of the questions that I would have answered. And so
I'm funny that way, but go ahead.
The only thing I would add is that alleged charge here is assaulted. He has a assault history, and then he said the bond violation and the period.
Motion for bond reduction is denied. Bond will continue. Thank you.
Your Honor, would you consider a tether provision? Mr. Buckner just consider permission to speak. He would also ask permission to speak.
Why? I'm willing to go on tether just to prove that I'm not an issue. I'm not out there trying. I'm just wanting to go to work, get back to work. That's what I've been doing since I was 14 years old.
The sequence of events are that you're before the court, don't appear. Then you go through the warrant recall process,
Which I
get
had
out, and then allegedly commit another offense.
with the retail fraud, sir. I never went in and got it.
Sir, at this point, I'd advise you not to speak about the so.
Okay, my ruling's still the same. Bond request denied. Bond will continue. Thank you.
Judge Gunner.
Court calls the case of the people. Here it is. That's it.
Motion. July 28th at 10 a.m.
July 28th, 2026, 10 a.m.
Yes, sir.
10 a.m. before Judge Barr. Bond continue.
Your Honor, as to bond, we are also here for a bond violation.
We are?
We are.
Okay, go ahead.
As to that, Your Honor, my client has been in for 21 days on the violation as of today. He would admit to the violation. He is the sole provider for his mother. However, she is very ill and needs medications. She needs those at proper intervals as well. Mr. Burroughs had placed himself into Don Farms after the initiation of this case on his own accord, but had to leave due to his mother falling, unfortunately. He'd also been in the hospital himself for several medical issues. He's asking for release with home confinement, any testing provisions that the court would deem appropriate to ensure compliance. We would just be asking for an opportunity for him to be out on bond prior to sentencing so that he can handle the pre-sentence investigation, interview, and also to begin taking care of his mother again.
But he didn't go over to community correction.
I don't think he went on time initially, Your Honor. And at that point, when he did go, I believe there was a diluted test for a positive.
Well, there was a positive test for cocaine and amphetamine.
That's my understanding as well.
This is arguably the strongest legal moment of the hearing because the focus changes from sympathy to accountability. The defense presents several compelling personal circumstances, an ill mother, medical issues, voluntary treatment efforts, and a request for GPS monitoring. However, the judge is evaluating whether those circumstances outweigh documented violations of previous release conditions. The positive drug test is especially damaging because it directly relates to the court's confidence in future compliance. When a defendant asks for another opportunity, judges often look for evidence that previous supervision was successful. Here, the record instead suggests difficulty following court-imposed conditions, making the defense's request considerably harder to justify. Notice the strategic adjustment by defense counsel. Rather than arguing that prior violations never occurred, counsel pivots toward risk management by proposing GPS monitoring and emphasizing the upcoming sentencing date as motivation for compliance. That's a practical courtroom strategy because credibility is usually strengthened by acknowledging weaknesses instead of ignoring them. But ask yourself this: does electronic monitoring actually solve the problem the judge is worried about? GPS can track someone's location, but it cannot guarantee lawful behavior or compliance with treatment conditions. That distinction frequently influences bond decisions in cases involving repeated violations.
Response from the people.
I believe that in court's discretion, it sounds like we have all of the plan for judicial safety on for June and for.
So how do I know he's going to come back? I did see that.
Well, Your Honor, I imagine that a GPS tracking tether would certainly help in that. Also, the simple fact of the matter is that you just informed my client. My client understands that he has a lot to lose between now and the time of sentencing where he had to violate. So I imagine that that might be incentive enough for him to come back. I think at this point, he just wants to handle it.
What's it?
All right, the defendant having admitted to the violation. I'll sentence the defendant to 21 days jail, credit 21 served.
Okay, good.
previous bond with its conditions, including community corrections reporting, is reinstated. Defendant also will be placed on the GPS tracking tether. Thank you.
Thank you.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Baker, who should be present via Zoom from the MDOC, the Thumb Correctional Facility. Sir, could you please state your name for the court?
Donald Baker. Thank you, sir.
Thank you, Your Honor. I do have here a green sheet. I am requesting an adjournment. I did get approval to visit my client in the facility, and I have been in communications with them as to scheduling a visit. It looks like it is likely to be an in-person visit either next Friday or the Friday after. That being said, I would ask for about a 3-week adjournment.
Excuse me, Your Honor.
Yes, sir.
How many adjournments we gonna have? I ain't seen no attorney since I got arraigned. I'm out of class. I'm in business class. I've been sitting at the machine waiting to see an attorney. I ain't seen nobody. I'm just sitting here every day waiting on somebody, waiting on a visit on the machine, waiting to talk to somebody, and it's just adjournment after adjournment.
If you were listening to Ms. Pate, indicated that she is coming within the next Friday. She had to schedule the visit. Sometimes that doesn't go as easy, but it's not on the PD's end. It's typically on the Department of Corrections end, making sure that she can meet with somebody can meet with you. So she intends to do that, and that is why she's requesting the adjournment. The court will grant the adjournment. Probable cause conference will be adjourned August 6, 2026, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor. Thank you, Ms. I'll be down just soon. I just got approval this week. Thank you, sir.
Court does call the case.
Other people, Your Honor.
Is he in law school in Iowa?
Yes, Your Honor.
They have one?
Yeah, it's a pretty good there.
I don't think so. All right, we'll see. You guys got it.
Oh, that's right. I'm sorry. When the music stops, we'll both grab a chair.
All right. Your name, sir?
Orby Huffman.
Thank you. What are we doing?
Your Honor, this is a case assigned to us. We have a patient with Mr. Huffman. He does not want our office to represent him. He has spoken with Bishop Moore from our office, who he indicates that he is going to retain, but I don't think he's spoken with any.
Okay, so you're going to retain counsel, sir?
No, I haven't misunderstood what he meant. If he's my attorney, that's fine.
Pardon?
Then
you guys, so never mind.
yeah, I'd ask for it to pen better. Maybe I can go back and talk to him.
I'm sorry, I didn't understand.
No, it's okay. It's all right. I just want to make sure we're getting everything so we can take him back. Is this it for them?
Names are not for the people, Your Honor.
Michael Gaddy, Assistant Public Defender for Mr. Huffman. Yeah.
All right, what are we doing?
Your Honor, I did have a chance to, this is a competency hearing.
Yes.
I did have a chance to review the competency report. Thank you for Ms. Landy for Beltis for forwarding it to me. And I've gone over that with Mr. Huffman as well. State your name, Mr. Huffman.
Orby Huffman.
Your Honor, we don't have any additions to that report. One correction, Mr. Huffman states he was born in Ohio, not Ypsi, but raised there. Other than that, we don't have any additions or corrections, and we don't object. We don't object to the report or stipulate to the report. Yes, Judge.
Anything from the people? Looks panicked.
No, Your Honor, we also stipulate.
Based upon a review of that report, the court does find that there would indicate that the defendant is competent to stand trial, would specifically find that the defendant can understand the nature and objects of the proceedings and against him and can rationally assist in his defense. Therefore, the defendant is deemed competent.
Thank you, Your Honor.
And I'll need an order.
Yes, I'm preparing one now.
And What would you like me to set this for then?
Your Honor, I'd ask for a probable cause conference. We have a stalking matter listed as well. I don't know if that's open or closed yet.
He has another case.
On our files, we have a stalking matter that's just I can't tell whether that's open or closed with the court. So I didn't want them to be staggered.
A felony stalking or a misdemeanor stalking?
Looks like an ag stalk. I can pull up.
An ag, so is it up in circuit court currently?
It's a.
Yes, Your Honor, it is.
It is.
Oh, it's in circuit court now.
Yeah, that's
All
what he said.
right, thank you, Judge. My fault.
Okay. So is that holding him? Is that holding him? Why is everything so hard?
Sure. All right.
Your Honor, it looks like his bond was denied in that case.
Yeah, he remanded in that.
Oh, okay. So yes, answer.
Yeah.
All right. I'll set his probable cause to August 6th, 2026, 9 a.m. Bond continues.
Thank you, Judge. Okay.
Looking across the entire hearing, a consistent judicial principle emerges. Judge Simpson repeatedly prioritizes procedural integrity and public safety over personal hardship. Each defendant presented circumstances that could naturally generate sympathy: family obligations, employment opportunities, medical concerns, communication problems, or frustration over delays. Yet the court continually returned to the same legal question: does the record support confidence that the defendant will comply with future court orders? In Mr. Buckner's case, the alleged new offense, while already under court supervision, significantly weakened the request for bond reduction. In the second matter, the court reached a different outcome because the defendant admitted the violation, accepted responsibility, received credit for time already served, and was released under stricter conditions, including GPS monitoring. That illustrates an important legal principle. Judges tailor release conditions to the specific risks presented rather than applying one outcome to every defendant. The later proceedings also demonstrate another fundamental aspect of criminal procedure. Whether addressing attorney scheduling, competency evaluations, or adjournments, the court focused on protecting each defendant's legal rights while keeping the cases moving through the judicial process. Delays may be frustrating, but they are often necessary to ensure effective representation and fair proceedings. The broader lesson is that credibility is built through consistent compliance, not simply persuasive explanations. Once a defendant develops a pattern of missed appearances or supervision violations, every future request for leniency becomes substantially more difficult. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.